Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. Hope you guys are having an amazing day. Hey, y'all, so this is a quick update on Buzbee's motion to appear his Pro Hoc Vice application. So there has been a big debacle and over the internet about him either being disbarred or not being able to practice in the Southern District of New York, and people are using terms in the wrong context. And also, I did a live to kind of confirm, verify, explain all of the above in regards to what happened. Now, as I explained previously, over, let me see, the 21st, and I'll click on the docket. You know what? Let me just do it now. On the 21st, he filed his motion to appear for Pro Hoc Vice. He also submitted his certificate of good standings for each of the federal courts that he has been admitted to. Okay, and he also attached the grievance order that shows that the grievance committee for the Southern District of New York denied his application for admission into the Southern District of New York. There was a filing deficiency because he did not, one, submit he didn't sign. He has to physically sign the Pro Hoc Vice application, the actual motion. He also had to attach his certificate of good standing for the Supreme Court and any other certificates of good standing that has been issued within the past 30 days. That is right here. It clearly tells you exactly as to why the motion for Pro Hoc Vice was rejected. It needed a wet signature, and they also needed a certificate of good standing from the Supreme Court of Texas. And any other certificates that he received. So if he had a certificate of good standing from the Supreme Court of New York, he would also submit that to refile the motion as a motion to appear Pro Hoc Vice. Okay? On the 22nd, they submitted a proposed order that has not been signed yet because they still have to wait for him to sign the Pro Hoc Vice motion and consider that. So I'm not sure why people are saying that they've already approved it. Nothing has been approved because he hadn't even submitted the motion with the wet signature on there. As you can see, that was just done today. So once he came back from his hunting trip, y'all didn't even give him time to enjoy his weekend, come back and do what he needed to do. So today, he printed out the motion. He signed the motion. He scanned it back to his computer and he uploaded and saved it to his desktop. Now, either he uploaded it to the Pacer website or the local counsel, the Mercer Law Firm, who is the lead attorney on the McCrary case, uploaded through their Pacer to get this filed. But either way, the motion to appear Pro Hoc Vice was uploaded today. He also submitted the notice. That's like a cover letter to the motion. So you have your motion that is now signed. You have the notice of that motion letting the court know that the motion has to be resubmitted. You have all of his certificates that he previously submitted, along with his affidavit, along with the declaration of the Mercer Law Firm, who is the firm that is going to sponsor Tony Buzbee if he is granted to appear pro hoc vice. All of this is for the McCrary case. This has nothing to do with any other case outside of this. A pro hoc vice means that you are allowed, if granted, you are allowed to appear in court on behalf of the plaintiff in the case that you filed your pro hoc vice application. Okay? This is the process. They have to apply for a PACER account. You have to file the motion to appear. You have to file the affidavit. You have to file the certificates of good standing that has been issued within 30 days from the attorney in each state court in which the applicant is a member of the bar. And then you also file the proposed order for admission, pro hoc vice. And then you pay the fee, which is $200. And you pay that when you upload it to the PACER system or the ECF system. That's it. That's all. So he did this for this particular case. If any other plaintiff in any other case wants the Buzbee Law Firm to be a co-counsel or work on their case, he's going to have to apply pro hoc vice for each case people are wanting him to work on. People have to realize, one, that all of Diddy cases, Buzbee is not the lead attorney, or he's not even nowhere on that case. There are other attorneys in the United States of America that practice law in the areas of personal injury. He doesn't, just because he is the forefront of the movement against Diddy does not mean that anybody, if they don't, some people don't even like Buzbee and don't want him to be on his case, so they're going to go with other attorneys. So I want people to understand that. So by him doing this for the McCrary case does not hinder in no way, shape, form, or fashion any of the other cases that are involving Sean Combs. Another thing that I want to speak about. Everybody wants to say, oh, is this the reason as to why the case was dismissed? Blase, blase, blase. Y'all have to realize that he submitted his. So when the judge in the other case, is this? Oh no, it's not. Hold on. I'm gonna pull this up for y'all, because I'm gonna pull up. Wait, was it the criminal case? No, it wasn't the criminal case. It was 07. Hold on. You know what? Let me just do it like this. So the case where Jay-Z was named, Buzbee. Now, even, and I agree with every single person on this internet. Why Buzbee decided to seek admission at the last moment, I have no clue. Because what I do know is that I don't know, this is still showing, but hopefully it should say terminated by now. Um where is that darn case? There we go. I done lost my darn train of thought. Oh yeah. So why he did what he did, there's no reason. Only Buzbee knows why he decided to file late. I don't know if he thought that he would get away with it. I don't know. Never seen it. Personally, any attorney that I am uh contracting with, if we know that we have a case in the southern in any type of district in any federal court and that attorney is not admitted, I automatically pull whatever application I need to pull and let them know, hey, you're not admitted in this district, or it shows that it expired and you have to reapply. And we do that at the beginning of a case because technically, even when you start a case on the federal level, in order, that's the first thing that you have to do. But what I want y'all to realize is that there was already an attorney on that case. The plaintiff attorney does not show Tony Buzbee or the Buzbee law firm. It shows Mr. Curis with the Mercer law firm. So when the case was initiated, right, it shows the Mercer law firm because they are already admitted in that district. Now, if the case, let's say that Busby wanted to file that case, right, for himself, like, and he would have to first, he would not even be able to go into Pacer and file any documents without first selecting the option that he was one either admitted into the Southern District of New York, or two, he would have to file the motion to appear pro hoc vice first. He wouldn't even be been able to file the complaint. That's how it works. It's not like the state court when we could file a petition and no. You, in order, you have to be admitted in that district. So if you're not admitted, you're not just going to go into Pacer and upload a complaint and start a lawsuit. It does not work like that. All right. Now, going back to the Jane Doe case. There was an order that the judge put out and stated that here we go. January 28th. On January 28th, the judge told Busby that he had to show proof of his admission on the docket by February 14th. Busby applied for admission, I believe, on the 29th of January. On the 29th of January, that is when Busby applied for his admission to the Southern District of New York. Hold on, let me go to Busby's. Let me see. Da-da-da-da. Or did he? I think that's what he did. I think on the 29th. It was not February, I'm sorry. January 28th is when this order on this case said, hey, Busby, you have to file proof of admission on this docket by February 14th. So he either had already submitted his no, he didn't, because he had to wait to get the certificates of good standing. That's what he posted on his Instagram to show y'all he had to get a certificate of good standing first. So more than likely, no. So after this here, this is probably what prompted him to say, okay, I need to go ahead and submit my application to the Southern District of New York for admission. Okay. This was January 28th. If we go back to the docket, that was the 28th. Then here comes, where is it at? Was it the 4th? Where, yeah, the 4th of February. So a couple of days, they respectfully request that Jay-Z's motion for sanctions be withdrawn, but without prejudice. So this is before they even said, okay, we're going to dismiss this case. So At this point, February 4th, they were still in the process of litigating this case. February 4th, so January 28th, the judge told Buzbee he needs to show proof of admission on file to the court. On the next day, more than likely, is already admitted in to get a certificate of good standing so that way he can submit his motion to appear pro hoc fi not I lied. So that he can actually be admitted. That's what I'm saying. Not the Viche. He still have to show a certificate of good standing when you're doing your application as well. So for his application of admission, he had to get his certificate. And that's what he was doing. Once he gathered those, then he can go ahead and submit his application for admission into the Southern District of New York. Because in the order that denied that petition, it stated that he submitted it on the 29th. So I answered my own question. So on the 29th, he submitted his application to be admitted in the Southern District, New York. They declined it because they said he was appearing in cases when he should not have. All right, so work with me on the timeline. The 28th, they said you got to show proof you're admitted in the district. The 29th, he completed his application and he submitted it to the court. On the 4th, Spyro withdraws the motion for sanctions, but without prejudice. So they had no intention at this time to drop the case. Because if they did, they would have said with prejudice and they could never ever file motions against him again. But they said with prejudice. That was the 4th. Then come on the 7th, we get a notice of voluntary dismissal for the Bad Boy Records. Then we come here to, what was that, the 14th, and we get the surprise of our life. The whole case is dismissed. Now, this has nothing to do with his application for admission to the Southern District of New York. He just failed to do that. Point blank, period. Jane Doe is the one who said, I wish not to continue with this case. So when a client comes and say, I wish not to continue with the case, we can't do nothing about it. So she agreed to never ever bring this up again through the courts. That's it. That's all. There's nothing more. So don't stop linking stop linking Buzbee's admission to the Southern District of New York with Jane Doe dismissing her case. Buzbee did not dismiss the case. All Buzbee did was file a voluntary dismissal and upload it on her behalf. That's all. Trying to think what else. Yep, that's all. So this case was not dismissed because Buzbee did not get admitted in the Southern District of New York or he postponed his application. This case was dismissed because Jane Doe wanted the case to be dismissed. And whatever they discussed behind closed doors, she agreed to never file against Diddy or Jay-Z again. That's all. That's why it's a voluntary dismissal. It's not a forced dismissal. It's not an involuntary dismissal. It is a voluntary dismissal. And in the pleading, it clearly states that the plaintiff, along with her attorneys, spoke with the other side, with their attorneys, and had this conversation. So let's stop linking his admission to the SDNY to the Jane Doe case being dismissed. There is no link whatsoever. It's parallel. It's not perpendicular. They're just, he just failed to do what he was supposed to do. And I blame him, and I do blame the staff, because they should have known better. They definitely should have known better. But as far what this whole video is about, it is about the McCrary case and the McCrary case only. His application to appear pro hoc vice under a sponsored attorney who is already admitted in the Southern District of New York, that has been refiled. It has been signed and it has been refiled today. So the judge is going to take a look at this, and if she approves or if she denies, this proposed order here is going to be signed. It is not signed, it is not dated. Nothing has been approved because he just refiled today. Not over the weekend, but today. Only the proposed order, which is not signed right here that I'm looking at, was the only thing that was filed. And I explained that to you guys last time. I don't know what happened between this weekend or yesterday or Saturday and now, but nothing has been approved. And I don't even want to say proved, because that is not the correct word. Granted. The order has not been granted. You will know when the order has been granted, because here it will say signed and it will have the date. Here it just says entered. I'm trying to think what else. You see how it says right here? Order on motion to appear pro hoc vice. I'm trying to do better with my pronunciation. That's what it would say. See? You see how on January 28th, Michael P. O'Day, he appeared pro hoc vice. He submitted everything that he was supposed to do. Here's the proposed order. He filed his notice. And then here it states order granting the docket. So the motion 42 motion, that's the docket number 42. So the motion that was submitted, it will then say that it was granted. And it will also read hereby ordered by Judge Mary Kay, whatever her name, last name is, and it'll show the date that it was entered. I don't know what else to say. I don't know how to make this in the simplest terms. But if y'all are watching the docket, find an example. So just like I went a few to January 28th on this exact same case, there are other attorneys that have appeared pro hoc vice. It shows how it's submitted. The day after, it shows when the order is granted, and it'll say that it was hereby ordered by the judge and when it was entered into the system. Please stop with the misinformation. If y'all have any questions, put them in the comments below and I will try my best to respond. Thank you for watching. Don't forget to like, share, and subscribe. And then until then, you all be blessed and have a good night. Bye.